Good morning. Happy Thursday. As you can tell by the way I'm dressed, I'm not in court. My 5-day trial is still on hold. We're waiting for a courtroom. It is a civil trial, and it's in Placer County. So the way it works is you set your trial date at a case management conference. Case management conferences are about every 90 days or so. The court inquires basically as to the status of the case and whether or not you're ready for trial. So about 6 months ago, I think it was about 6 months ago, at the last case management conference we had, I represent the plaintiff and the defendants, we both agreed that I represent the plaintiff, and I, along with opposing counsel who represents the defendants, agreed that we were ready for trial, and the court offered us dates, and we picked September 26th as the date. And there was a settlement conference. There was a trial confirming conference where the court said, "Are you really ready to go?" And we're like, "Yeah, we're really ready to go." The trial confirming conference was about a week before, I think, if I remember correctly. I don't remember the exact date. I think it was a week before, maybe 10 days before the date the trial was supposed to start. And then on the day before the trial is supposed to start, Master Calendar sends out a calendar. Well, they publish a calendar and they call you if you're going to go to trial. Now, the problem is in Placer County, there are 2 courtrooms available for civil cases because all the other courtrooms are taken up for family law and criminal trials. There's 2 courtrooms available for civil trials. All the rest of the courtrooms are taken up by hearings or mostly criminal trials, and then family law trials are the second most common thing. And that's generally not an issue because about 98% of civil cases settle before they go to trial. Generally, only 2 kinds of cases, civil, go to trial. Losers, like where the plaintiff has absolutely no case, and $1 million cases. Now, the case I'm going to trial on isn't $1 million case, but I also don't think it's a loser. So there are some times like where the case that I'm going in on to trial eventually, theoretically, is a case where there's a lot of emotion. Family is suing family. So there's a lot of emotion involved, and I think that's the problem, and that's why we weren't able to settle it. Now, what happens is for the next 2 weeks, well, the remainder of this week, I mean, theoretically, they could call me today after 3 o'clock and say, "Hey, you're going to trial tomorrow." But theoretically, for the next week and a day, so for a 2-week period, I'm just on hold. I'm just circling the airfield, waiting for a runway to open up for me to land, right? And then if it doesn't go to trial, essentially, it's going to go back to another trial confirming conference. We pick a new date, and the process starts again. My understanding is that because this is the first time this case is up to bat, it's very low likelihood that this case is going to actually get a courtroom and go to trial. So why am I telling you this? Why am I telling you this? I'm telling you this because Earl's trial was continued to December 7th, I believe, if I remember correct. It was set, I think, originally for September 15th, and then the court reset it like on its own motion for September 29th. I could have those dates wrong, but generally speaking, it's roughly thereabouts. And then somehow I checked at the beginning of the week or at the end of last week, I don't remember which, and Earl's case had been continued out to December 7th. Now, Earl's claiming a couple things. He's claiming that he's going to sue the district attorney, Kim Ogg, and that's silly. Much like a lawsuit against a judge, prosecutors enjoy prosecutorial immunity. Again, for taking things to trial, for charging, etc. Just because they lose doesn't mean you could sue them. Just because things don't go your way doesn't mean you could sue them. So they have prosecutorial immunity, very similar to what a judge would have. Anything really connected to the prosecution, not administrative or things outside of the prosecution, or if they act like investigators or anything like that. But as far as like the case is concerned, anything like related to prosecuting the case, they have immunity for. So he's going to have a real hard time if he does that. I think Earl's just talking. I don't think he's going to actually do it. Earl has never had good follow through with his lawsuits. I mean, he's about as bad as Chili is. Number two, he was originally saying on his Discord, and I only know of this because there was a very exuberant young man who would take screenshots of everything that Earl said and posted in my Discord. But apparently, Earl was initially his attorney. His attorney allegedly, according to Earl, didn't know anything about the reset. Allegedly, according to Earl, the district attorney or the assistant district attorney who is prosecuting the case for the state of Texas changed the trial dates on her own without consulting his attorney, and apparently allegedly has direct access to the court's calendar and can reset trials without anything from the court or from the defense. And allegedly, Earl's attorney was going to file a motion to have the case dismissed based on failure to prosecute. There is a lot of problems with that. Number one, the court controls its calendar. The court sets when things are heard or not heard. The court does that, and not the assistant district attorney or the district attorney. The court sets its calendar. That's number one. Number two, in my experience in California, specifically, I've had criminal cases in Placer County, El Dorado County, and was that Sutter County? Yuba City Courthouse is Sutter County. So I've had criminal cases in 3 counties. And in all 3 of those counties, whenever you would make an appearance, if things are getting pushed out at all for any reason, the court in all 3 counties will ask, do you waive time? Every time they'll ask, do you waive time? You say, hey, I'm waiting on getting a blood test back. The sample's getting tested for the DUI. I'm waiting for a blood test back. Okay. So when do you need to hear it? Yesterday, literally yesterday I was in court. I'm like, hey, I need October 26th. And the ADA who was there, I don't remember which one it was. It wasn't the actual one that was assigned to the case, but they always have an ADA there in every single one of those courtrooms who's basically representing the people for it. It's like, the state has no objections to that. And so it got reset. And then she's like, okay, we'll reset it. Do you waive time? And I had to say, yeah, I waive time because we're moving it out, right? Now, I don't know. Every county I've done anything criminal in has done things different. They all have different things. There are a few things that remain the same. Like they'll ask you every time you're like, hey, I need to continue this. Like, hey, do you waive time? That's a constant. So I'm assuming that is due to the 6th Amendment right to a speedy trial. And I assume, without knowledge, that they would also ask that in Texas. I assume that. So that may vary. I don't practice criminal law in Texas. I don't practice any law in Texas, but I specifically don't practice criminal law in Texas. And I don't know how they do it specifically in Harris County and how Earl's specific judge does it. I think Frank Aguilar was his judge. I saw Frank Aguilar as a judge. Maybe that's the presiding judge or something. Anyway, that's neither here nor there. But generally speaking, if you have been waiving time, you have to assert that you're no longer waiving time in order for things to not be getting put out further. In Texas, having done a modicum of research, they do a motion for speedy trial. So initially you have the right to a speedy trial. If you have waived it and you want to reassert it, you file a motion for speedy trial. The result of the motion for speedy trial is the court sets your trial date. Boom. Now, I have not seen Earl or his attorney file a motion for speedy trial. If they do that, if the court does that, and then you don't get heard in that at that time frame, then maybe you want to start looking at a motion to dismiss, because the court's going to look at several things. Number one is, was this delay uncommon? Now, I can't speak to how it's been about 4 years, Earl's saying. I think he was arrested in 2019, so I don't know exactly how it's been 4 years, but he's getting close to 4 years. I think he was arrested in the spring of 2019, if I remember correctly. So, I mean, we're getting 3.5, maybe we're getting to 4 years. Is that uncommon? Now, there was COVID in there from in 2020 to 2021 that might have been affecting court operations. So that's like, is it uncommon at this point? That's one of the questions they're going to look at. They're going to look at, was the delay caused more by the prosecution or by the defense? And you got to remember, there were a lot of resets that were done by defense requests. So the court is going to have to weigh that out if he wants to get this dismissed. Who's more at fault? Is it the prosecution or is it the defendant? And then they're also going to look at the reasons why it was delayed. Like, I mean, are there good reasons for the delay? For example, on this this last one where he was set for September 29th and it got kicked out to December 7th, was that on the court's motion because the court had a full calendar or the court had a conflict or something like that? Was it on like, hey, you're supposed to start trial in my courtroom, but I have an ongoing criminal trial that is still going on, so I can't hear two trials in my courtroom at the same time, so I have to kick you out to a later date? Or was it the prosecution who did some sort of an ex parte motion to say, hey, maybe I'm in trial still on this case, so I need to have it kicked out because I can't be prosecuting two trials at once? Or who knows? Like, I don't know why the court continued that hearing. I know, or at least I'm certain. I shouldn't say I know. I'm certain that the assistant district attorney cannot continue a case on her own. She doesn't have the power to do that. The court controls its calendar. And then the last thing they're going to look at is, what kind of prejudice has this caused Earl? How is it affected him? And that's going to be a balancing test. Is the prejudice it caused to Earl sufficient to offset some of the rationale of why it was continued? And, the court might look at things like, attorney's costs. Has it cost him more money? Has he been in jail the entire time, or has he been out on bond? Has it negatively affected his ability to conduct his business because he has to make time to appear at all these hearings, etc.? So, I mean, there's things that the court's going to look at, but the court's going to balance those four factors and look at those four factors. Oh, I'm sorry. I condensed two of them, or one of them, into two. I expanded one of them into two. It's who has requested it more, and the justification is the second factor. The third factor is, has the defendant asserted his right to a speedy trial? Has he done that? And to the best of my knowledge, to date, Earl has not asserted his right to a speedy trial. He's waived it. There's been no evidence that I've seen on the court's website to say that he's filed some sort of a motion for speedy trial. So that's really going to weigh against Earl. I mean, that's going to be a real problem. I'm not saying it's going to be fatal, but it's a real problem. Now, the last thing is that he he alleges that the district attorney altered the online record to remove the September 15th, the September 29th hearings to somehow affect his motion for dismissal. And that online record is not the official record. It's not. It's what the court publishes. It is not the record. The fact that it doesn't reflect on their website is immaterial. In addition, you can see still on the online record that the last hearing was reset to September 15th. Now, it doesn't show that September 15th hearing or why that September 15th hearing was continued to September 29th. I believe it was continued on the court's motion on that one. And it doesn't show the September 29th hearing or why it was continued to December 7th. But the actual record, the file that the clerk's office has is going to have that information in there. I can't say certainly. I mean, courts make mistakes. I've seen things not end up in files before, but that's the practice. That's how it works. The online record isn't the record. It's what's in the actual court's file. When you file appeals, you're not presenting new evidence like, oh, look at the court's online record. The clerk's record would be the actual file that has all of the filed documents in it. That would be sent to the Court of Appeals along with any court reporters transcripts for any of the hearings. It's a felony. I believe they have to have a court reporter's transcript to preserve all of the testimony and all of the pretrial hearings for appeal. So, I mean, if someone intrepid wants to go to Harris County and see if they can get those court reporters transcripts, those might give us a bit better insight into what's going on in Earl's case. Because just going by the record on the court's website is, I mean, there's a lot of gaps there that we don't know why things happen. We know what's happened, we just don't know why. So anyway, that's kind of your update. I don't anticipate a motion to dismiss for failing to provide a speedy trial is going to succeed. The balancing test, the factors the court's going to look at isn't. I don't think it bends Earl's way, because at least two of them, who requested more delays, who requested more continuance. The defense requested most of them, at least initially. As far as whether Earl has asserted his right to a speedy trial, to date he hasn't. So, I mean, those two things weigh heavily against him. How much prejudice it's caused him and the state's rebuttal to that, we don't know. And is it abnormally long? I don't know what happens in Harris County. I would guess 3.5 to 4 years is a long time, but I don't know how long it normally takes to get to trial. And he's certainly not under a constitutional, until he reasserts his right to a speedy trial, he's not under any constitutional deadlines to get to trial. I mean, it's just whenever it comes up. So anyway, thank you for watching and have a great day.